Be ready. Start. During lifetime of Ram Singh, an application dated 8th April 1992 was filed by Sushila Singh, opposite party, number 2, for release of following documents viz. 5 FDR, item number 89 of inventory dated 28 January 1992, 2 Unit Trust of India, gift, wide, item numbers 90 and 91 of the inventory dated 28 January 1992, sale deeds, wide, item numbers 95, 96, 97 and 101 of the inventory dated Patna High Court, miscellaneous number 25,391 of 2013 and item number 4 of the inventory dated 18th July 1990. The aforesaid application was rejected wide order dated 21st March 1996, which is as follows: as has been urged at bar, petitioner does not happen to be the owner proprietor of most of the articles, release of which was sought by her, as some of those properties are shown to be of son and daughter-in-law and grandsons. Secondly, I find that though investigation had been conclusive and petitioner facing prosecution for amassing wealth disproportionate to known source of her income, and those properties seized during investigation are liable to confiscation in the event of petitioner found guilty. Apart from that, I find that most of these documents and articles would also be required to be explained in the case if situation warranted, and in that view of the matter, I find that there was no good cause for release of document in favor of petitioner, and prayer for release is accordingly rejected. Put up on 20th April 1996 for supply of police papers. From the record, it appears that on 12th April 2013, a petition was filed by Sushila Singh, opposite party, number 2, for release of the properties in her favor. Subsequently, another similar application dated 20th August 2008 was filed by opposite party, number 2, Patna High Court, miscellaneous number 25,391 of 2013, for and on behalf of grandchildren, and rejoinder to that application was filed by the petitioner resisting the claim of opposite party, number 2, and petitioner has also separately filed a petition for release of the properties. While the matter was pending, again a separate application dated 12th April 2013 was filed and made a prayer to institute a separate miscellaneous proceeding to facilitate to release of document which they are entitled to. The case was registered as miscellaneous case number 1 of 2013. The rejoinder was filed by the petitioner where it has been stated that Sushila Singh, opposite party, number 2, did not have right to claim over the property of Ram Singh. Hence, the driver had slowed down the vehicle, at which point of time the bus had dashed against the rickshaw and the driver had fallen on the bonnet of the bus, and the bus had thereafter dashed into the cabin of the panwala. That everyone started saying that an accident had taken place, hence he ran into driver's cabin and pulled the handbrake, and later on he came to know that 2 persons had died in the incident. According to the said witness, when he pulled the handbrake, the driver was lying in an unconscious condition on the bonnet and he had also sustained head injuries. The said witness had further deposed that at the time of the accident, the bus was going at a very slow speed and that when the driver regained consciousness, he had inquired from him as to what had happened and was told that the driver had injured his head when he dashed against the grill and had become unconscious. It is submitted that in the light of the evidence of the conductor who was present with the driver in the bus, it is apparent that the driver was not driving the bus in a negligent manner and that the bus was going slowly and it was only because a rickshaw suddenly came across that the bus had dashed with the said rickshaw, whereupon the driver had sustained head injuries which had resulted in his becoming unconscious. Therefore, both the courts below have erred in coming to the conclusion that the prosecution had established the guilt of the applicant. It is submitted that considering the fact that most of the witnesses, including the punches, had turned hostile, as well as considering the evidence of the conductor, the trial court was not justified in convicting the applicant and the appellate court was not justified in confirming the said conviction. Alternatively, it is submitted that if the court is not convinced on the merits of the case, the court may consider modifying the sentence by reducing the sentence imposed by the trial court and may consider granting the benefit of the provisions of the Probation of Offenders Act 1958 to the applicant, considering the fact that the accident had taken place in the year 1993 and hence after a delay of 17 years it would not be just and proper to compel the applicant to undergo imprisonment at this stage and age. It is submitted that the applicant is a poor person and has been dismissed from the services on account of his conviction, that he does not have any criminal antecedent and as such he should be granted the benefit of the provisions of the Probation of Offenders Act.